Meeting. So, yeah, please come up to the table, have seats. So we are here today to discuss recent court decisions which have construed the limits of Pennsylvania's Sexual Offenders Registration and Notification Act, which is also more commonly referred to as Megan's Law. We're joined by our good friend, Dave Freed, District Attorney for Cumberland County, former president of the DA's Association, and a frequent testifier before this committee. And I have to say, on behalf of the committee, congratulations on your nomination by the president to be the U.S. Attorney for the Middle District of Pennsylvania.
Thank you.
We're also joined by Major Scott Price and Captain Beth Riedler of the Pennsylvania State Police. Thank you all for joining us on this very important topic. As I said before, this is an important issue affecting all of Pennsylvanians. Megan's Law was originally enacted in this state in 1995 as a result of Governor Tom Ridge's special session on crime. The law has continued to evolve over the years. Changes have sometimes been based on court decisions, but they've also been the result of changes in technology, such as in 2004, when information on registered sexual offenders was first made available over the internet. The latest comprehensive update of Megan's Law was actually enacted in 2011 under Governor Tom Corbett. After each version of Megan's Law is enacted, it is inevitably subject to challenges in court. We're here today because of one such case, the case of Commonwealth versus Muniz, and the complicated fallout from that case. So once again, thank you for being here. Look forward to your testimony. Before we get started, I'd like to ask everyone on the committee to introduce themselves. I'm going to go to my far right over there in the corner.
Dan Miller, Allegheny County.
Ryan Bizzaro, 3rd District, Erie County.
Brandon Newman, Washington County.
Joe Petrarca, Democratic Chair, Westmoreland, Armstrong, and Indiana counties.
Ron Marsico, Chair.
Tom Costa, Allegheny County.
Rick Saccone, Allegheny and Washington counties.
Joanna McClinton, Philadelphia and Delaware counties.
Paul Schemmel, Franklin County.
Ted Nesbitt, Mercer and Butler counties.
Becky Corbin, Chester County.
Having a little technical thing here, Chairman. Jeff Pyle, Armstrong, Butler, and Indiana counties.
Jerry Knowles, Berks, Schuylkill, and Carbon counties.
Jesse Hopper, Bedford, Franklin, and Fulton counties.
There you go.
All right. Tom Dimick, Committee Executive Director.
Chair Petrarca for remarks.
Thank you, Chairman. First, like to introduce an intern that we're going to have in our office this fall, Alex Fernandez from Newman University through the Bipartisan Management Committee Internship Program. Not Brandon Newman University, but Newman University. Glad you're with us. Look forward to your input as we go through the fall session. I agree with the chairman. Obviously, Megan's Law, a very important subject for all Pennsylvanians. Since it was enacted, it has protected many Pennsylvanians in our communities. We are aware of it through the action of the state police and the legislature. I know that, as Chairman said, there's still actions going on in the Pennsylvania courts regarding this issue, and we will see where that ends up. In the meantime, though, I'm certainly glad that you are all here today to hear your testimony as we move forward again on this important subject. Thank you.
Thank you, Chairman. Just for the record, we received testimony yesterday from Jennifer Storm, the victim advocate, Pennsylvania. So with that, then you guys may begin. Whoever wants to go first.
Sure, I'll dive in. And good morning, everyone, and thank you for having us here. As always, Chairman Marsico, Chairman Petrarca, are always incredibly responsive to the needs of law enforcement. If you'll allow me a moment of personal digression, I think it's been something just over 10 years since I first appeared here as a witness on behalf of PDAA. And I have always appreciated the reception from my friends on this committee on both sides of the aisle, who, while we may not always agree, I know are always trying to work on behalf of the best interests of their constituents. So thank you for that. It's entirely possible, while not presuming confirmation, that this is my swan song here. So if it is, I'm happy that it is here in front of this committee. As Chairman indicated, my name is Dave Freed, and I'm the Cumberland County District Attorney and currently Communications Chair for the Pennsylvania DA's Association. I am also the District Attorney in the county that prosecuted the case of Commonwealth versus Muniz, and have fought the appeals all the way up through the Pennsylvania Supreme Court, and we are currently, along with our colleagues in the Attorney General's office, and I spoke with the Attorney General himself yesterday, who's been a great partner in this with us. We're currently working on our cert petition for the United States Supreme Court. We're working hard on that, and we have received a stay from the Pennsylvania Supreme Court in Muniz in its effect, at least as it relates to our specific case. There's a little bit of a debate about how broadly that applies to other cases around the Commonwealth, and as you'll see, there's debates on just about every tiny aspect of this case. We need a statutory fix in order to ensure that we have robust and constitutional sex offender registry in Pennsylvania. Now, during this meeting and my testimony, certainly you'll hear phrases like sex offender registry, Megan's Law, Adam Walsh Act, SORNA, which is an acronym for Sex Offender Registration and Notification Act. That's our present version of Megan's Law. While these terms mean slightly different things legally, which I'll explain later, they generally refer to our sex offender registration system and process. That process includes the following. Number one, requirements that sex offenders register and verify their information, such as address and place of employment. Number two, provisions that make it a crime to fail to comply with these obligations. And three, the process by which sexually violent predators are designated. Four, the rules and guidance regarding what information is publicly accessible in our state's sex offender registration website, which, as you know, is maintained by the Pennsylvania State Police. How did we get here today? On July 19th, Pennsylvania Supreme Court decided Muniz, as we said, and they ruled that the provisions of SORNA that applied retroactively were unconstitutional because they were punitive. As a result, such retroactive application violated the ex post facto clause of the federal Constitution. An ex post facto law, among other things, increases the penalties for a crime after it has been committed. Ex post facto laws are unconstitutional. I think we learned that in social studies in elementary school. And as I said, we litigated Muniz. Now, Muniz in particular was convicted of indecent assault of a child under 13. He was convicted in 2007 and failed to appear for sentencing. He was picked up on a warrant and came back and was sentenced in 2014. By which time the latest version of Megan's Law or SORNA had been enacted. So by the time Muniz was sentenced, and it would have happened anyway if he had been on supervision, his registration requirement changed from 10 years to lifetime. He immediately took steps to appeal and file a motion to have his registration declared to be 10 years at the time of his sentencing, which was denied, and he was made a lifetime registrant, and that's what triggered all these appeals. So it's a 2007 conviction, 2014 sentence for an indecent assault of a child under 13, which is essentially fondling without penetration. Now, I'm going to do some legislative history, but bear in mind, unless there's a legislative change, and this is very important, there's general agreement on the numbers. I don't think there's exact agreement on the numbers, but there's a very real possibility that people who committed the crime for which they had to register as a sex offender before December 20th, 2012, which is the effective date of the statute that was struck down in Muniz, they may not be able to be prosecuted for failing to meet their registration or verification obligations and may be removed from the Megan's Law website. So there's the potential that they'll just be removed, and there's certainly the potential that if they just flat out fail to register, we won't be able to prosecute them for that offense based on where we stand today. So in 1995, we enacted Megan's Law, as the chairman said. In 1999, the 1995 law was found to be unconstitutional because it created a presumption that certain criteria made someone a sexually violent predator and subjected them to enhanced penalties of a maximum life term or a requirement of lifetime registration. So the following year, Megan's Law 2 was enacted. Megan's Law 2 removed that presumption, placed the burden on the Commonwealth to prove by clear and convincing evidence that a sex offender was a sexually violent predator, which is defined as an individual suffering from a mental abnormality that makes it likely that the person will engage in predatory sexually violent offenses. They were no longer subject to automatic increased maximum terms. The Pennsylvania Supreme Court did strike a provision providing for mandatory criminal penalty of lifetime probation for failing to verify registration and an additional penalty up to life imprisonment for failing to verify registration information. In 2004, the General Assembly improved Megan's Law dramatically by enacting Megan's Law 3. Most significantly, in Megan's Law 3, the new law required that information about sex offenders and sexually violent predators be publicly accessible on a website. That's an issue that we're going to have to deal with because our Supreme Court found that, at least under our current version, that the way that our information is I don't know, broadcast isn't the right word, but is made available to the public, subjects the offender to shaming. The Act also increased certain penalties for failing to register or verify and added new crimes to the list of crimes that triggered registration. Another issue that we'll have to deal with, I think. In 2006, we further improved the website, or you did, by enacting new laws that required the same categories of info be placed on the website, would also be required to be placed on the website about sex offenders who were not deemed sexually violent offenders. That included street address, whether the victim was a minor. In 2006, legislation was also enacted that reduced the time period for an offender to first register from 10 days to 48 hours. In 2011, and this was very important, and was actually quick work by the legislature following some court decisions that had a real impact on what was going on in Pennsylvania, because sex offenders were locating here because of the out-of-state loophole, purposely coming here. I think any prosecutor you talk to would tell you they had a case in their county where the person specifically came to Pennsylvania because of the out-of-state loophole. We had a couple from Kentucky and Ohio in Cumberland County. The loopholes were closed that permitted out-of-state sex offenders and transient sex offenders to avoid registration. In 2011, Adam Walsh was enacted, leading to the statute in 2012. SORNA, as required by federal law, and those of you who were here throughout that process recall the lengthy and robust debate that went on and the extensions that we had to get to try to come into compliance. SORNA required an increase in the number of crimes subject to registration, increase the length of time, as happened to Muniz in the case that we have in Cumberland County, increase the amount of information that had to be included in the registration information and the amount of information on the public website. Also required juveniles adjudicated delinquent for a limited number of sex crimes, rape, involuntary deviant sexual intercourse, aggravated indecent assault, to register on a non-public registry. That was ultimately struck down by our Supreme Court as unconstitutional in a case out of York County. Nearly 20 states are in compliance with SORNA. States that are not in substantial compliance receive a 10% reduction in federal justice assistance grants, which are typically used for Pennsylvania and for public safety purposes. They certainly are in Pennsylvania, and support a lot of the training that goes on for prosecutors and defense attorneys and police. Also required by federal law, our SORNA statute was retroactive, meaning anyone who, on the effective date of SORNA, was incarcerated, under county or state supervision, or on the registry, was subject to the new requirements. As I said, it's this provision that was the subject of Muniz. In 2014, our Supreme Court in Commonwealth versus Neiman struck Megan's Law 3, the version that was enacted in 2004, for violation of the single subject rule. And as a result of that, the General Assembly enacted new legislation to ensure sex offenders were not allowed to evade registration requirements. The new law included provisions preventing an individual who was designated a sexually violent predator prior to Adam Walsh taking effect from challenging his or her status. This was necessary because the 2004 law made changes to the process by which an individual would be determined to be a sexually violent predator. Importantly, The law also ensured that those convicted of luring a child into a motor vehicle and institutional sexual assault must continue to register. And institutional sexual assault, if you'll recall, is our statute that's often used in a school setting when you have a school employee or a teacher involved in a sexual relationship with a student that doesn't necessarily rise to the level of an indecent assault or an ag indecent assault. Those people are required to register as well. Now, one more important point to make as it relates to the sexually violent predator process, and I think this is always important to point out. The process is well summarized on the website of the Sexual Offenders Assessment Board. So in order to have someone deemed a sexually violent predator, a convicted sex offender who has a mental abnormality or personality disorder that makes the person likely to engage in predatory sexually violent offenses, every person has to be assessed by the Sexual Offenders Assessment Board to determine whether that person is assessed as a potential sexually violent predator. That has to happen within 90 days of conviction and prior to sentencing. If the SOEB says that that person is not a sexually violent predator, we just proceed to sentencing. If they say that the person is potentially a sexually violent predator, they have to submit a written assessment. Well, both ways, they have to do it in writing based on criteria in the statute. And then we have to have a hearing prior to sentence where the Commonwealth must prove in court by clear and convincing evidence that the individual meets the statutory criteria. So just because SOAB says that the person is a sexually violent predator doesn't mean that they're designated that by the court. There's then an additional proceeding where the Commonwealth has to prove by clear and convincing evidence to make that person a sexually violent predator. SVPs, sexually violent predators, have to register for life, verify their information quarterly and in person, receive monthly sex offender counseling for life, and be the subject of active community notification. Now, some have questioned whether sex offender registries work or otherwise represent good policy. On behalf of my colleagues in the DA's Association, I want to share some thoughts on that issue. The underpinning of sex offender registries is that sex offenders are dangerous. They prey on our most vulnerable and commit crimes that can result in a lifetime of struggle and challenge for the victims and their families. They're high risk and they recidivate. There's a significant amount of literature and studies attempting to measure the risk posed by released sex offenders. And while there is some social science discussing how dangerous released sexual offenders are, there's no social science asserting that sexual offenders are not dangerous or do not recidivate. Nor is there any social science asserting that new sexual crimes by released sex offenders are not of great concern. And there's a study that laid out here, and this is also in an amicus that we filed on behalf of the DA's Association that followed almost 10,000 male sex offenders from 15 states and found that nearly 4 in 10 returned to prison in 3 years. Another study spanning a 25-year period, and the exact sites for these studies are in a footnote in the testimony. Rapists and child molesters remain at risk to offend at least 15 to 20 years after discharge, and that the sexual recidivism arrest rate for rapists was 39%, for child molesters was even higher at 52%. Equally significant is that any statistical attempts to measure the risk of new offenses greatly understate the true nature of the problem because the vast majority of sex crimes are never reported. Victims and parents of victims frequently do not report because they fear further victimization by the offender, retribution by the offender's friends and family, loss of privacy, risk of not being believed, embarrassment, trauma from the criminal justice system, and fear of poverty. A lot of this is discussed very well by our wonderful victim advocate in her testimony. This all means one thing. Assessments of the threat posed by released sex offenders are certain to underestimate the risk. Do sex offender registries help mitigate the risk that released sexual offenders pose? My colleagues and I believe they do. To be sure, looking at sex offender registries can never be the exclusive way in which an individual tries to keep him or herself or her children safe. We have to remember that a child predator is more likely to be someone that a victim or her parents know, that we should be suspicious of adults who make special efforts to be alone with children, and that we need to listen to what our kids tell us, that women can be sexual abusers, that we should talk to our kids about specific suspicious situations to be cautious of, such as adults asking children for directions. If used as a tool and not the exclusive tool, sex offender registries do provide important information for protecting children and adults from sexual predators. Now, Why are we here? We're here because of the decision of the Pennsylvania Supreme Court in Commonwealth versus Muniz. And Muniz didn't happen in a vacuum. I mean, these challenges have been built up over time. There are companion cases about it. My good friend, Representative McClinton's former colleague, Aaron Marcus from the Philadelphia Defenders Association, and I teach this every year at the Criminal Law Update for the Pennsylvania Bar Institute, and things are changing every year. There's multiple challenges going on all the time. But where we are is that the decision has been made. Now, we're pursuing an appeal in the United States Supreme Court. We feel that we have an excellent case to make to have certiorari granted, but we never know whether it'll be granted, and then whether, if it's granted, what the result will be. Now, with regard to Muniz, I disagree with the ruling. I don't think the requirements are punitive or onerous. It does place significant burdens on those required to register. The scope of those requirements do not, in my view, rise to the level of punishment. That's why we've decided to pursue this case. Now, those affected by the decision, as I indicated earlier, are those who committed their registration crimes before the effective date of Pennsylvania SORNA, which is December 20, 2012. In other words, if a person committed a rape before December 20th of 2012, he or she may not be required to register, nor may he or she be prosecuted for failing to register. This is because SORNA, which was effective on that day, is no longer retroactive. Because it is not retroactive, and because the prior version of Megan's Law 3, was replaced by SORNA, there may not be a sufficient statute in place to put any registration requirements on these offenders. There could be 10,000 such individuals. There could be more. If those individuals fail to register or verify, we may not be able to prosecute them. And whether they would remain on the registry remains an open question. So can we prosecute them? There's a debate on that issue. Does the Pennsylvania State Police have to remove them based on Muniz? There's a debate on that issue, and believe me, those challenges are already taking place. Counties are grappling with cases of sex offenders who failed to verify, but who, as a result of Muniz, may not have been required to register at all. Every county in the Commonwealth has one of those cases, guaranteed. The situation doesn't have to be completely dire. In my review, with regard to some of these cases where SORNA no longer applies, we can certainly argue that as a matter of law, prior, although less robust versions of Megan's Law would apply. We can argue, for instance, that the 2011 law that closed the out-of-state and transient loopholes in Megan's Law effectively reenacted parts of Megan's Law 3, and thus without SORNA, that's a version we can rely on. We can also argue that the 2000 version of Megan's Law applies, since that version was eliminated by revisions that the Supreme Court found to be unconstitutional in the enactment of Megan's Law 3. While we can't say with certainty what will happen, I could say that if the U.S. Supreme Court does not accept Muniz, then thousands of sex offenders may very well not face penalties for failing to register, and thousands of sex offenders may be removed. It has the potential to affect every single sex offender convicted before September 20th, 2012. Every registrable offense, not just the minor ones, the major ones. It will then be up to the Pennsylvania State Police to determine whether they should remain on the registry and to litigate any attempts to remove those sex offenders from the registry, and there will be thousands. With all that said, there is room for a legislative fix. We at PDAA have already been working with committee staff. We recommend reenacting a version of Megan's Law that was in place before SORNA took effect in 2012. It should apply to offenders whom SORNA applied retroactively, meaning that their registration crimes were committed before December 20th, 2012. Under this proposal, some offenders would ultimately come off the registry, but the numbers would pale in comparison to the possible 10,000 who could ultimately be removed from the registry. Now, it's hard to separate the two, but I think we have to. There's the challenge to the Supreme Court decision in Muniz, which we will litigate. We'll have amicus. My friends from the Defenders Association will be on one side. We'll be on the other side. Pennsylvania Association of Criminal Defense Lawyers will be out here, and PDAA will be out here. And we'll fight that battle. And we'll see if we can get cert granted. And if so, we'll fight that battle up in the Supreme Court. So in a legal sense, that'll be interesting, and we'll have to face the challenges as prosecutors, and Pennsylvania State Police will have to face those challenges. We'll have to deal with that. But I think that we need to focus here on what do we need to enact to make sure that we don't end up with that worst case scenario, which is the 10,000 or more people coming off the registry and that number that we can't prosecute. I want to thank you, as I said at the beginning, not just for today, but for more than a decade of your help and attention and your friendship. If I'm fortunate enough to be confirmed, I'll leave PDAA with a smile on my face. It'll be hard to leave my friends and the greatest job in the world, and working with you has made that job even better. So, Mr. Chairman and Chairman Marsico, Chairman Petrarca, thank you so much, and I'll be happy to answer any of your questions after the rest of the testimony.
Before we move on, let me just acknowledge some of the members that came in. Representative Delosier, Representative White, Representative Stevens, Representative Nesbitt, Representative Davis, Representative Briggs. So, welcome, members. Go ahead, you may begin.
Good morning, Chairman Marsico and Petrarca, and members of the House Judiciary Committee. I'm Captain Beth Radler, Director of the Policy and Legislative Affairs Office for the Pennsylvania State Police. With me today are Major Scott Price, Director of the Bureau of Records and Identification, Captain James Fisher, and Trooper Sean Geibel, also of the Bureau of Records and Identification. We appreciate the opportunity to provide testimony today to discuss the impact of a recent state Supreme Court decision on Pennsylvania's sexual offender registration system. What is known as Pennsylvania's Megan's Law, Title 42 of the Pennsylvania Consolidated Statutes, Chapter 97, Subchapter H, was first established in 1995. Legislative amendments to the law became effective in 2000, 2005, and 2012. These various versions of Megan's Law are often colloquially referred to as Megan's Law 1, 2, 3, and 4, or SORNA. As Megan's Law 4 adopted the guidelines enumerated in the Federal Sex Offender Registration and Notifications Act. Megan's Law 3 was struck down by the court in its entirety, and because this effectively nullified the repeal included in law, abiding legislation reverted to Megan's Law 2. As such, our testimony today will encompass Megan's Law 2 and SORNA. The Pennsylvania Sexual Offender Registry is maintained by the Pennsylvania State Police and currently includes approximately 22,000 active offenders. A significant number of these offenders were added to the registry subsequent to SORNA implementation on December 20th, 2012. Under Megan's Law 2, sexual offenders were subject to registration requirements with the Pennsylvania State Police for certain enumerated offenses. Those offenders were subject to either a 10-year or lifetime period of registration. In either case, the offenders were required to update and verify their personal information on an annual basis. The information collected included, but was not limited to, address of residence, employer, school, and temporary habitat as applicable. If an offender required to register under Megan's Law was incarcerated while on the registry, the period of registration told during the incarceration period. This information was maintained by PSP. However, at the time of enactment, there was no Megan's Law public website. The public website was established under Megan's Law 3 and was subsequently made a provision of SORNA. When SORNA became effective in December of 2012, numerous significant changes to the statute were enacted. SORNA implemented a much more comprehensive, robust registry in order to keep sex crime victims, law enforcement, and members of the public better informed and make personal safety decisions prudently as applicable to their situations. The number of enumerated offenses which subject an individual to registration was expanded, thus capturing a large number of offenders who had not previously been required to register. A tier system was enacted, which changed the registration duration and frequency of updates. Offenders are classified and required to register for 15 years annual updates, 25 years semi-annual updates, or lifetime quarterly updates. Those previously convicted and subject to the 10-year or lifetime registration requirement were reclassified under the tier system and subject to the new registration requirements if they remained incarcerated or under supervision at the time of enactment of SORNA. The personal information collected was also expanded and included, among other things, vehicles owned and operated, including air and watercraft, international travel documents, internet identifiers, and personal or occupational licensing. Much of this information is made available on the public internet site. Upon enactment, SORNA essentially repealed all prior versions of the law. In July of 2012, the Pennsylvania Supreme Court issued a ruling in Commonwealth v. Muniz. In interpreting this ruling, PSP determined the registration requirements currently in place under SORNA are deemed unconstitutional when applied to registrants whose offenses occurred prior to the date of enactment. While the full impact of this decision is yet to be known and potential appeals may ensue, PSP has begun to perform preliminary assessments to gauge impacts and plan for contingencies. This decision, as interpreted, likely impacts over 17,000 offenders, including over 1,000 designated by the Sexual Offenders Assessment Board, SOAB, as sexually violent predators. A review and determination of the appropriate registration status of each of these individuals will be required. Case reviews will verify the offense date, specific offense committed, registration requirement at the time of offense or negotiated by plea agreement, and any subsequent offenses and/or periods of incarceration. In some instances, it may be required to remove offenders from the registry entirely. While these case reviews proceed, PSP will also be required to determine how the registry is to be managed with regard to those offenders awaiting sentencing evaluations. Should we simply be required to inactivate the registry pending the case reviews, past experience has revealed that we will be unable to locate approximately 16% of those offenders who would ultimately be required to remain on the registry due to factors such as relocation. There are two scenarios we determined to be plausible. Either of these potential scenarios will have a marked impact on management of the registry and, of greater concern, detrimental impacts to our public safety posture. In the first scenario, any person whose offense occurred prior to the enactment of SORNA will not be required to register. PSP has received several court orders asserting SORNA repealed all prior versions of Megan's Law, and in light of the Muniz decision, there is no statutory registration requirement for offenses occurring prior to December of 2012. In this interpretation, an offender arrested and convicted after December 2012 would not be required to register if the offense occurred before that date. Registrants whose offense occurred prior to the enactment of SORNA, but who were arrested and convicted post-SORNA, would require removal. And should future prosecutions occur in cases in which offenses occurred prior to SORNA, no registration would be required. Those found to have reoffended post-SORNA would remain on the registry. The second scenario involves a registrant whose offense occurred prior to SORNA, but to whom reversion to Megan's Law 2 would apply, resulting in either 10-year or lifetime registration. Many of those reclassed to the 10-year requirement would be removed from the registry, as their registration requirement will have been fulfilled. Those reverting to the 10-year requirement would require analysis to verify their registration period has expired and that they have not reoffended, while also accounting for any tolling due to incarceration. Additionally, extensive technology revisions would be required to make necessary changes to the Megan's Law database and public website. This scenario does, however, blunt the negative public safety ramifications associated with complete nullification of registration for all pre-SORNA offenders. The Megan's Law section currently is staffed by 5 enlisted members, 12 legal assistants, and 8 clerical positions. The burden of case reviews would fall primarily to the legal assistant staff. We estimate this endeavor will consume approximately 8,575 staff hours, predicated upon experience with similar case reviews conducted at the time of enactment of SORNA and in response to previous court decisions. The average hourly salary with benefits for the legal assistant staff is $36.27 an hour. This equates to a projected cost of just over $311,000 in staff hours for the case reviews. If conducted during business hours, in addition to the normal day-to-day business of the Megan's Law section, it would likely require 12 to 18 months to complete these reviews. The implementation of required changes to the Megan's Law database and public website would potentially require up to 12 months to develop and become operational. The time frame and cost would ultimately be dependent upon the level and complexity of the changes that are required. In accord with our public safety mandate, PSP urges consideration of legislative action which would formalize reinstatement of most registration provisions of Megan's Law 2 for pre-SORNA offenders. These provisions have been vetted by the courts and found to be constitutionally sound. In order to blunt the impact on management and development of the database, inclusion of language to ensure permissibility of maintaining the entirety of the body of information captured for each offender required by SORNA would seem prudent. Extensive revisions would be required if PSP is unable to retain current data set for offenders in any amended legislative scheme. Similarly, PSP would also support, from a policy perspective, additional legislation which would authorize PSP to continue to keep pre-SORNA offenders on the Megan's Law website. However, in light of the Supreme Court's ruling in Muniz equating the public website with public shaming, any such proposal to keep pre-SORNA offenders on the Megan's Law website would have to be carefully considered to determine if it could even be constitutionally enacted. It may simply not be possible. Also, if the case review burden could be eased if pre-SORNA out-of-state offenders were simply required to register based on their state of conviction requirement. Although it is difficult to predict a finite cost estimate at this time, additional expenditures related to this transaction are inevitable. In the most palatable scenario, these costs will not be insignificant. Confidence and trust in our judicial system is imperative for the victims of all crimes, none more so than those of sexual crimes and abuse. Should no action be taken and challenges to reversion to Megan's Law for pre-SORNA offenders be successful, a very large number of currently registered sex offenders will no longer be required to register. The impact on the ability of victims and the public at large to make decisions regarding their safety will be compromised, and the psychological impact on victims patent. Furthermore, pre-SORNA offenders could very well relocate to Pennsylvania merely to escape registration requirements. Were this to occur, the premise of SORNA to close potential gaps and loopholes that existed under prior law and generally strengthen the nationwide network of sex offender registration and notification programs would be further compromised. Thank you for the opportunity to provide you with our perspective, and we'd be happy to answer any questions you may have at this time. Thank you.
We'll go to questions. Representative Saccone.
Thank you, Chairman. Thank you for your testimony. So if I'm understanding this right, and I just want the public to understand this too, I was trying to look this up on the internet, but I didn't do it fast enough. We have 22,000 active sexual offenders registered in this state, and this glitch or this Supreme Court decision will affect 77% of that list, which means we would lose 77% of that list if we don't make it a legislative change. Is that what we're saying here?
Yes, sir. Prior to SORNA, we had about 13,000 registrants on the database. That's grown to about 22,000. I think as of this morning, it was 22,060 or thereabouts. Our worst case scenario estimates suggest to us that potentially we could be left with only about 3,500 offenders remaining on the registry and 19,000 or 18,500 removed.
Yeah, that's alarming. And I just want one more question. You may know this or not. I was trying to look it up. But how does Pennsylvania rank with the number of sexual offenders on the registry compared to other states? Do we have about the same? Is there a lot more? Are we in the middle? Do you have any idea at all?
I think I would say in the top third, California has the most. I believe California's registry encompasses over 100,000 sex offenders, but Pennsylvania is certainly in the top third based upon the most recent numbers that I've seen.
Okay, thank you very much.
Representative Stevens.
Thank you, Mr. Chairman. Thanks to the panel for your sobering testimony. So I was a sex crimes prosecutor from 2000 to 2010, so I guess all of my offenders are within this bunch. So I'm very familiar with how dangerous many of these individuals are and deeply concerned about the ramifications of this case. One of the things that strikes me is that it seems as though, aside from the address updates, which I certainly understand the value and importance of, at the very least, you know, all the docket sheets are publicly available. And I know, Captain Riedler, you made mention of some language in the case that made reference to the website being shaming. You know, with the public availability of the docket sheets, which include, I believe, the offender's address at the time the offense was committed, is that right? Do you know? Does anyone know if the AOPC docket sheets include that address?
I believe the docket sheets do.
I think that's still there.
So publicly available is already the individual's name, the individual's date of birth, potentially the individual's address, the county, and certainly the county in which they committed their crime. In terms of their photograph, whether it's an arrest photo or a subsequent photo, do any of you know if there are purely Pennsylvania statutory impediments to releasing them publicly?
Sir, and we've looked at that in the context of CREA, Criminal History Records Information Act, and I don't know that there's any clear guidance, but generally, at least in the opinion of our Chief Counsel's office, the photograph in and of itself, if stripped of identifying data to include SID numbers, FBI numbers, PII, personal identifying information, it has generally been the opinion of our counsel's office that the photograph in and of itself is not protected by CREA. Again, that's an opinion of our counsel's office. I don't know that there's any court guidance.
So, at the very least, even without SORNA, you could potentially provide, putting aside this idea of shaming, because I don't think informing the public that someone has committed a crime is shaming any more than obviously AOPC must think of it, since all their docket sheets are public. Putting that aside, I mean, you could create a website of the 18,500 people that were affected by this court decision and include their name, the address at the time of the offense they committed it, the county in which they committed the offense, their date of birth, and their photo. Today, right? Would seem to be the case?
I think you could, but then you wouldn't necessarily know when to take them off and things like that. But yeah, yes.
Well, they would never have to come off because they will have always been convicted.
That's true.
Of those crimes at that time. And that is all information that is readily available today. I mean, from my iPad, I can go access any of that information, except I'm going to guess most of the DAs released an arrest photo probably at the time of the press release that accompanied many of these cases, particularly with the Sex Offender Assessment Board and the Sexually Violent Predator determinations. So I guess in the interim, has there been any discussion about taking that approach to at least keep the public informed of these individuals? Look, I'm not at all suggesting it's a perfect fix, but we have this gap and we have 18,500 dangerous people who are about to be, completely unaccounted for. Has anyone discussed the ideas of amassing what's already publicly available and putting it into one place for the public to access?
Not specifically that idea, but this issue of what can be public in the context of the shaming is something that I believe we have to tackle. Law enforcement around the Commonwealth, I can tell you those of us that have booking centers, processing centers, which is most of us now, have followed, I don't know that we want to call it guidance necessarily from PSP, but followed, everybody is generally agreed on the arrest photo stripped of all that other information. That is not protected criminal history record information, so those photos are going out. And the media, I can tell you, is used to that, to getting those photos from booking centers. You know, there's if you followed our recent Supreme Court opinions in many cases, they are long and they are complicated. There's a lot of language and there's a lot of writing coming out from that court and a lot of different pieces of all these opinions coming out. So we have to focus on a lot of the discrete parts of these opinions. On the shaming issue, there's language from Justice Kennedy in a 2003 case about Alaska. Justice Kennedy says, the fact that Alaska posts the information on the internet does not alter our conclusion. Notice of a criminal conviction subjects the offender to public shame. This is along lines with what you're saying, Representative Stevens. The humiliation increasing in proportion to the extent of the publicity. And the geographic reach of the internet is greater than anything which could have been designed in colonial times. These facts do not render internet notification punitive. Now, of course, our Supreme Court can say you have more protection in Pennsylvania than you do under the federal Constitution, as they are wont to do. But the purpose and the effect to inform the public is for its own safety, not to humiliate the offender. Widespread access is necessary, and in fact, going on right now, as you said. I can't tell you, and with Crime Watch websites and the UJS portal, people have access to this information. So, what are we putting out there that's more than that? And how are we packaging it, I think, are questions that we've got to discuss, because I do believe there is a way to get most of this information out there. Now, some of it is going to be information, and there are differences in, Megan's Law 2 and what was struck down. I believe some of those differences, there are things that can be added and still pass muster.
And Representative, if I could just add to what DA Freed indicated, keep in mind too that under CREA, anyone, if you have information on your neighbor or someone who you're just curious about, you can go into Patch with the name and date of birth, and through Pennsylvania Access to Criminal History, you can obtain a complete redacted copy of a criminal history. Obviously, we take the non-conviction dispositions off as per CREA, but having said that, we're talking here about conviction dispositions. So predicated upon the fact that information is widely available, it's packaged differently. It requires an overt step to make a search of an individual's name, and we respond with a redacted criminal history. It goes to DA Freed's point regarding packaging. The information is available, but it's difficult to get. And you lose the things. I think one of the great technological enhancements that we made, by using that public website. So you go in and you enter your zip code in our Megan's Law functionality, and now you get a notification if a sex offender moves into or out of your jurisdiction, a certain radius. We lose those kinds of things. So it's a matter of packaging. The information's there, but it's not as accessible.
So think about that, though. If we have information on there that meets muster, do we have to get rid of that searchable zip code thing? I would argue no. And I don't know what kind of feedback you get from your constituents, but people love that.
No question. No question. Do you know, I mean, obviously we have a lot of addresses in our PennDOT database, vehicle registrations, driver's licenses, things like that, and our other databases throughout the Commonwealth. Has anybody taken a look at whether we might be able to utilize those statutorily, if we made statutory changes to access those databases to provide that as close as we could get an update to a current address?
From the PSP perspective, as it stands now, and I don't know what the legislation would look like, but because we access the data through either JNet or Commonwealth Law Enforcement Assistance Network, the security requirements for that access, i.e. be law enforcement or criminal justice, I don't see a pathway that's immediately obvious that would allow us to make that information publicly available.
But I just wonder, with a statutory change, if that could be accomplished. All right. I appreciate your testimony and insights here.
Well, thank you. We have like 5 minutes, and we have two members that have questions. Representative Newman.
Thank you, Mr. Chairman, and thank you all for your testimony today. A lot of my questions Representative Stevens had asked and inquired about. My question in general, other than maybe making a clearinghouse readily accessible for our constituents that would definitely meet constitutional muster, is there a way that would not be punitive for our law enforcement to continue to have access to where these individuals are, maybe without having a direct update so that you have this information? We want to make sure that you know where everybody's living and where they've been, even while we are waiting for these Supreme Court decisions. And if the Supreme Court is unfavorable towards our statute, we still want you to have that information. Do we have to do anything statutorily, or is this already available for you that they have to tell you where they're living And I don't know if you have any comments or if we have to do something statutorily. I think that we would be willing to do that.
I think it would require, if we're going to go that route, I think it would require some action legislatively, and I think that's an excellent idea, and you should maybe run for judge or something. I thought we were supposed to stand when you talk, but no, that's I think my perspective and opinion on this is clear. I'd like to see it remain publicly accessible.
Yeah,
but
we all would.
But the idea of requiring that information so that law enforcement can keep an eye on things, I think is sound. Today's Tuesday, right? Yeah, I got my 6 a.m. email, as I get every Tuesday morning at 6 a.m. from PSP Megan's Law, about who's compliant, who's not compliant in my county, and that is a very useful law enforcement tool, and we need to keep that kind of thing going.
In the compliance issue, I want it to be clear that it's not punitive in any way. So it's a difficult line that we're trying to toe here with not making it punitive. So how do you get them to register if there's no consequences if they don't register? Well, it's going to be tricky until we actually see if this statute's going to be upheld or not.
But I think that the case that's rather easily made is registration in and of itself isn't punitive.
Okay, good. And congratulations on your appointment. Good luck.
Thank you.
And I'd add to that, sir, also, keep in mind, we'll find a way to make the law enforcement information available. What we do now, we get essentially a compliance report quarterly from AOPC, which we bring into our database. And then we compare anyone who's been convicted of a predicate sexual offense to who's actually registered. And that's how we determine if we have a gap in compliance. If legislation weren't to come to fruition, or we will find a way, utilizing that kind of technology, working with our partners at AOPC and JNet, to ensure that we get the law enforcement, the information to law enforcement in some way. It may not be as efficient, but we'll find a way to do it.
Okay, thank you very much.
Representative Costa.
Thank you, Mr. Chairman. My question will be, I'm not a lawyer or a future judge, so it'll be short. What is the urgency once we get this packet, this proposed bill? What is the urgency? I want to make sure my colleagues understand how quickly we have to get this thing passed and try to get it through to the governor's desk.
It's an urgent, emergent situation because, as I said, we're going to fight our battle, and we know that things move slowly in the courts. The Supreme Court, not quite as slowly as some others, but things move slowly. So we need action to ensure that we don't end up with that worst case scenario.
All right. Thank you very much, and congratulations again.
Thank
Good
you.
luck.
Representative Khan.
Yes, but real quickly, I had a chance to look this up right now, and I have this question for you. So in 2005, we had 7,200 people on our list. 2015, 18,000. Now we're at 22,000 people on this list. 500,000 nationwide in 2005. 830,000 now across the nation. Is this reflective in the way we report, or is this reflective of the sickness of our society?
No, I think part of it is the effectiveness of the registration requirements of SORNA. If you think about pre-SORNA legislation, where most offenders were 10-year registrants, you had an inflow and an outflow where the offenders would come into the registry, they'd be there for 10 years, and then they came off the registry. Now, because somewhere around 78% of our database are lifetime registrants, you have an inflow, but you don't have an outflow. So the efficacy of the SORNA legislation in having a greater population remain on the database for life, I think, is what contributes to that growing number.
Okay, thank you. Thank you very much.
Representative Saccone, I think we've come a long way in reporting in Pennsylvania, so we certainly have expanded reporting, but my short answer to your question would be yes.
Well, thank you very much. I just want to say that I can assure you and the public that both chairs and the committee and staff will work as quick as we can on this legislative fix.
Thank you.
And also, just one more thing, Dave, you've been a very valuable resource for this committee and a very good friend. So we appreciate all the time and resource and energy you put into for the committee and also for Pennsylvanians. So thank you very much, and this committee is adjourned.
Thank you.
Thank you.